What unexpected ways can a conservatorship be modified or ended? Imagine a situation where someone thought a conservatorship was set in stone, but then surprising changes happen. That's because conservatorships can be altered or ended in ways you might not expect. First, if the person under conservatorship, called the conservatee, begins to regain their mental or physical ability, the court can end the conservatorship. This might happen after recovery from an illness or injury, or if their cognitive skills improve. The conservatee or interested family members can ask the court to review and possibly end the conservatorship if they show evidence of restored capacity. Another unexpected way is through court-ordered changes to the conservatorship scope. If circumstances change, the court can limit or expand the conservator's authority. For example, if the conservator was managing all financial and personal decisions but now only needs to handle finances, the court can adjust those powers. Or if the conservator is not doing their job well, the court can replace them with someone more suitable. These modifications can happen during regular reviews or if new issues arise. Sometimes, less restrictive options become available that can replace or reduce the conservatorship. For example, if the individual can make some decisions with support, a supported decision-making agreement or a power of attorney might be enough. If these alternatives meet the person's needs, the court may decide to end or lessen the conservatorship. In some cases, the person under conservatorship might have agreed to it voluntarily before losing capacity. If they later decide they no longer want the conservatorship or can revoke their consent, they can petition the court to end it. This is often seen when the conservatorship was set up while the individual still had some ability to make decisions. Unexpected life changes can also lead to modifications. Moving to a different state, changes in health, or new family support can prompt a court review. The court's goal is to keep the conservatorship as limited as possible while still protecting the person. If the conservator is not fulfilling their duties properly or conflicts arise, the court can replace them. This change might also include adjusting the powers the conservator has or setting new terms for the conservatorship. And of course, the most natural ending is when the conservatee passes away. The conservatorship ends automatically at that point. All these options show that conservatorships are not set in stone. Courts prefer to keep them as minimal as necessary and regularly review them. Attorneys often help families petition for changes or termination when the person's situation improves or when less restrictive options are available. This approach helps protect the individual's rights and dignity while making sure their needs are still met.